In this subunit, we're going to discuss the common law exceptions to consideration. All right, in this subunit, we're going to focus on the common law exceptions to consideration. Specifically in this subunit, we're going to focus on the majority approaches, which I call piggyback consideration or repromise. No one else uses that term, but I hope it's helpful for you. And then in the next subunit, we'll talk about the minority approaches. So let's right now focus on the majority approach to exceptions to consideration in the common law, what I call piggyback consideration. All right, here's the setup for piggyback consideration or repromise. So promisor makes an original promise which is supported by consideration. And then promisor makes a second promise, just reaffirming the original promise. It's really not a new promise, it's just reaffirming the old promise. But there is no new consideration for the second promise, the reaffirmation. So you might ask yourself, well, why a second promise? Well, sometimes the first promise will be unenforceable for some other reason, right? We said the first promise, the original promise, is supported by consideration, so it is not enforceable for lack of consideration, but it might be unenforceable for some other reason. And then when the promisor reaffirms that promise, there is no need for a new consideration. So let's go through each of the situations where a promise that is originally supported by consideration might be unenforceable for some other reason, thus giving the need for a second repromise or a reaffirmation of the first promise. I call it piggyback consideration because the second promise, the reaffirmation, is piggybacking on the original consideration for the original promise. So we'll talk about why a contract might be unenforceable because the statute of limitations has run, or because the statute of fraud says this contract must be in writing, or because bankruptcy makes the original promise unenforceable, or maybe we have some formation defense that makes the original promise unenforceable, or the last one, the unliquidated debt, is not quite the same, but when parties have some sort of unliquidated debt, uncertain debt, and they agree to make it certain, then there's no need for a new consideration. Let's go through these one by one so you have a good idea of what they are. First, let's look at a situation where the first promise, the original promise, is unenforceable because of statute of limitations. So Mary lends money to Bob, and Bob promises to pay Mary back plus interest by January 2010. Bob's promise is supported by consideration, right? We can see that there's consideration here. So what happens, though, is that Bob never pays and Mary never sues. The statute of limitations on, we'll just assume it may not be depending on your jurisdiction, but let's say that the statute of limitations for Mary to sue is 6 years and Mary has not sued. And so her opportunity to sue on this, it has passed, and so therefore Bob's promise is unenforceable. On February 1st, 2016, after the statute of limitations has already run, Bob sends an email to Mary saying, "Don't worry, I will pay you back." There is no consideration needed for this new promise. Mary can now sue under this new promise, but there is no consideration, no new consideration needed. It piggybacks on the consideration for Bob's original promise. All right, let's talk about the statute of frauds. We haven't learned about the statute of frauds yet. We'll learn about the statute of frauds in Unit 7, but here's the statute of frauds, and this is just one example. The statute of frauds is a statute that says when a contract may not be an oral contract, when it must be in writing. If these types of contracts are not in writing, a court will not enforce it. And contracts for the sale of an interest in real property must be in writing. If they're not in writing, a court will not enforce it. So, contract for a sale of an interest in real property, you cannot have an oral contract. So here's our fact pattern. Mary and Bob enter into an oral contract. Mary promised to buy Bob's land for $100,000. It's an oral contract, so it will be unenforceable. 1 week later, Bob asked Mary to sign a written contract for their sale of Bob's land. There is no new consideration needed for the written contract. It's not really a new promise. It's just restating the old promise, the original promise, and there was consideration for the original promise. Therefore, if you want to think of it this way, the new written promise piggybacks on the consideration for the original oral promise. Moving on to the next topic, bankruptcy. Here's our fact pattern. Mary lends money to Bob. Bob promises to pay Mary back plus interest. Bob's promise, of course, is supported by consideration. But before repayment, Bob declares bankruptcy and all his debts are discharged in bankruptcy. His promise is no longer enforceable. But he may reaffirm his promise to Mary. He may say, Mary, I will reaffirm my debt to you. This reaffirmation requires no new consideration. Now, you might be saying, why would Bob reaffirm his debt if it's discharged in bankruptcy? Well, that's another matter when you take a course in bankruptcy. But for now, if he does reaffirm a debt that is discharged in bankruptcy, there is no need for a new consideration for that reaffirmation of his promise. Once again, it's not a new promise, it's just restating his old promise, and therefore it piggybacks on the consideration that supported his old promise. All right, now moving on to the next topic, formation defenses. In Unit 8, we'll talk about a lot of different formation defenses. Let's just use one as an example, incapacity. So in Unit 8, we'll learn that a minor that enters into the contract can avoid a contract. The contract is voidable at the option of the minor. And of course, a minor is, for our purposes, someone who has not yet turned 18 years of age. So here's our fact pattern. Bob is 17 years old. He'll turn 18 next month. Before he turned 18, he entered into a contract to buy Mary's house. Bob's promise is supported by consideration, right? But his promise is voidable because he has not yet reached the age of majority. So he may void that contract. When Bob turns 18, he says to Mary, now I'm 18, I reaffirm my original promise that I made when I was 17. No new consideration is needed for this reaffirmation of his promise. His original promise was supported by consideration, and now his reaffirmation, his restatement of that old promise needs no new consideration. It piggybacks on the consideration that supported the original promise. Moving on to our next topic, when the parties have an unliquidated debt and they settle that unliquidated debt. What does unliquidated here mean? It means uncertain. So it means one party owes money to another party, but they don't know how much. That's an unliquidated debt. Let's look at two situations. The first one is the indefiniteness example. Remember, we talked about indefiniteness in Unit 4. Here's an example. Buyer and seller agreed to the sale and purchase of a house for a fair price. All right, so you look at fair price, you know it's vague. How much? We don't know. Maybe this contract is unenforceable because it's vague, but this is what happens. The parties later agree to a price of $800,000. No new consideration is needed for that agreement to liquidate the debt, right? It was an unliquidated debt. That means uncertain. They liquidated it, meaning they made it certain. So there is no new consideration needed for the settlement or the agreement to liquidate the debt. All right, let's look at another situation where we have an unliquidated debt, the quasi-contract example. So you're already really familiar with quasi-contract, so I won't go into a detailed fact pattern. Let's just say that party A has a good claim of quasi-contract against party B, right? But we have to figure out the dollar value of the benefit. Remember, under quasi-contract, if I have a good claim against you, I can recover for the benefit I conferred upon you. Well, we have to give a dollar amount to that benefit. If the parties agree to a dollar amount, so in this case, the parties agree, all right, let's make it $5,000. If the parties agree to that, there is no consideration needed. Okay, so you can think of this as there's no consideration needed because you're piggybacking on the original obligation of the quasi-contract, or you can think of it as that anytime parties settle a good faith dispute, there is consideration.